Hello and welcome, welcome. Thanks for joining us today. We're going to be talking today on our webinar about LGBT parents becoming a family, establishing parental rights and responsibilities here in New Jersey for LGBT parents here in the Garden State. Of course, our disclaimer first, this presentation contains general information and does not constitute legal advice. Please be sure to direct your specific questions to your own attorney about your own case. So, what we're going to talk about today with regard to becoming a family here in New Jersey for our LGBT listeners: introduction, adoption, assisted reproduction, psychological parent doctrine, and the basics of New Jersey custody and support law as it applies to every parent here in New Jersey. So, our introduction, let's get started. Becoming a family, a goal and a challenge for many couples. Now, many same-sex couples adopt children, and many others have children that are the legal, natural, or adopted child of only one parent of the couple. Couples should clarify their intentions and parental status as early as possible in their relationship so there's no confusion in the courts down the road. Now, becoming a family, establishing legal parental status. Why is establishing legal parental status important? Legal parents make many important decisions for minor children. So if you're sharing legal custody of your partner's child, you have the opportunity to make those important decisions for your child with your child's other parent. A parent's legal status may entitle children to certain benefits such as health insurance coverage, inheritance rights, Social Security benefits, life insurance, pension payments, and veterans benefits. If parents split up, legal status will control, and the legal status affords you rights to custody or parenting time, and also the responsibility for payment of child support if that is indicated. Now, state law generally controls parental status. Laws pertaining to adoption do vary from state to state. Adoption is not a federal law. Laws regarding parental status based on assisted reproduction vary from state to state, even more so than the adoption laws. And of course, as we all know, laws are changing rapidly due to advances in reproductive technology. So, what about the parental status of genetic or birth parents? So, before a third party can gain parental status, the rights of one or both genetic or birth parents must generally be terminated by these few ways. So, voluntary donation of a gamete or an embryo, which may or may not sever all rights of the donor prior to a child's birth. Voluntary surrender of a child to an agency such as DIFAS in compliance with all legal requirements, made more than 72 hours after birth. This goes to adoption as well. Or voluntary or involuntary termination through an adoption or termination proceeding in court, again, like through a DIFAS, now known as DCPNP proceeding. So part 2, let's talk a little bit about New Jersey adoption basics. So what are your adoption options here in the Garden State? Well, there are several avenues to becoming an adoptive parent here in New Jersey, and they include a state agency adoption, a private agency adoption, which could be an out-of-state or an international adoption or an in-state adoption, a private placement adoption, or a second parent adoption. So, a few questions to consider when you're considering adoption here in New Jersey. Number 1, are you eligible for second parent adoption? Your partner, your significant other has a child. Are you eligible to adopt that child? Are you interested in working directly with birth parents if you're going to go the adoption route from a birth couple that you don't know? What is your budget for fees and expenses? Adoption, including a home inspection, can get pricey. Would you consider acting as a foster parent? Here in New Jersey, if you want to adopt through the state, you have to be a foster parent first. How do you feel about open versus closed adoption? Would you want the adoptive parents involved? Are you interested in pursuing an international adoption? Would you consider adopting a child of another race? Finally, would you consider adopting a child with a medical condition or handicap or special needs? So what can you expect with regards to New Jersey adoption? Well, requirements differ depending on the type of the process. Second parent or step-parent adoptions are generally easier with fewer requirements. But be prepared for some or all of the following: criminal and child abuse background checks for everybody, disclosure of financial, medical, and employment information, personal references, and perhaps a home study, or several or one home visit. Now, adoption through a state agency. The New Jersey Office of Adoptions is within the Department of Children and Families, Child Protection and Permanency. This was formerly known as DIFAS. Now, as a state agency, DCF does not discriminate on the basis of sexual orientation. The majority of children are placed through the foster care program, and the state will pay for certain expenses associated with foster care and with state adoptions, including attorney's fees. For more information on a state agency adoption, you can go to the Office of Adoption's website, or you can call 1-877-New Jersey Foster. What about private agency adoptions? Well, many private licensed adoption agencies in New Jersey are friendly to gay and lesbian individuals who wish to become parents, either on their own or with a partner. The All Children, All Families initiative of the Human Rights Campaign maintains a list of agencies that have met or are seeking to meet 10 benchmarks in LGBT cultural competency, so you can look that up. With private agency adoption, a child is generally placed in the home for 6 months before an adoption hearing is scheduled, just to make sure it's a good fit for everyone. Be sure to ask any agency very detailed questions about their policies and the success rates that they enjoy. What about private placement adoption? In a direct adoption from birth parents, the adoptive parents must file a complaint for adoption within 45 days of receiving the child. The parental rights of the birth parents are generally not terminated until a preliminary hearing 2 or 3 months later. New Jersey law prohibits paying anyone to act as a birth mother or to locate a birth mother, but it is permissible to pay a birth mother's prenatal and general medical care, plus certain other expenses that might be related to the adoption. Definitely consult with an adoption attorney before entering into any private placement agreements with birth parents. What about out-of-state adoptions? Well, adoptions of children born out of the prospective parent's state of residence, here in New Jersey, must comply with the Interstate Compact for the placement of children. Now, this ensures that children are uniformly protected, especially from child trafficking, regardless of which state they are moving to or from. Now, the interstate process may take a bit longer, and a prospective parent may need to stay in the placing state pending completion of the process. Consult with an experienced adoption agency in that state to be certain that you understand what will be involved in the out-of-state adoption process. And now, what about international adoption? International adoption can be a bit more expensive and certainly more complicated than adopting a child within the U.S. because depending on the country, it may also be more challenging for single gay or lesbian parents or same-sex couples to adopt. Some couples have found it easier for one partner to adopt a child as a single parent and for the partner to complete the second parent adoption here in the U.S. Consult with an attorney who is familiar with the procedures in whatever country it is you're considering and any applicable restrictions in your country of interest. What about second parent adoption? So second parent, or also known as co-parent adoption, is adoption by a person petitioning for joint parental rights when another person who is already a legal parent wants to co-parent with their partner. So this procedure is available for same-sex or opposite-sex couples where one partner is the natural parent or one partner already has adopted a child as a single parent. A second parent can file for adoption in New Jersey based solely on the fact that the child was born in New Jersey, providing that the filing is completed within 3 months of the child's birth. So now let's talk a little bit about assisted reproduction and parental rights here in New Jersey. So, assisted reproductive technology, it's been a boon for same-sex couples for several years now, and as well as infertile couples of really any sexual orientation. So, 2 moms can now use donated sperm while one of them carries the child. 2 dads can use a surrogate and a donated egg or embryo. The proliferation of options really has created a challenge for legislatures and courts who are trying to keep up with science while also fairly determining competing parental claims in these types of cases. So the Baby M case, you may or may not be familiar with this case back in the 80s where the New Jersey Supreme Court declared that contracts covering traditional surrogacy, where the surrogate carries a child conceived from her own egg, were completely invalid. In that case, the contract promised the surrogate $10,000 cash. The biological father and his wife were to adopt the child. When the baby was born, the surrogate refused to give up parental rights, and the court invalidated the contract that was signed, stating that no parent can contractually relinquish parental rights. So that was really a landmark case here in New Jersey. Now, we also have a statute regarding this. It's called the New Jersey Parentage Statute, and that confers legal status on a child's natural or adoptive parents. Now, a natural mother need only prove she's given birth to the child. A natural father can pursue various other routes, including acknowledging paternity formally or undergoing DNA testing. Now, the statute makes it fairly easy to raise a presumption of paternity because its major purpose is to ensure that a child is acknowledged and supported by 2 parents, regardless of gender. So the marital presumption of paternity and the timing of birth. So the parentage statute that we just talked about makes it especially easy for fathers married to biological mothers to establish paternity because it is presumed under the statute that a man is the biological father of a child if he and the mom were married, or in some cases really simply intended to be married, and the child is born either during the marriage or within 300 days after termination of the marriage. So what about marital presumptions of paternity and artificial insemination? Well, Section 9:17 of the Parentage Statute also provides that a husband will be the legal father of a child if, with both spouses' written consent, his wife is artificially inseminated with donated semen under physician supervision. Now, the semen donor will have no parental rights unless the mom has signed a written contract with him to the contrary. Let's talk about the parentage statute and challenges to its constitutionality. Is the statute constitutional? So language referring to her husband or his wife and to father or mother instead of parent is gender-based. So should we change that? Now, gender-based differentiations may be valid if based on real biological distinctions between men and women. But the statutes will be interpreted in a way that is constitutional, aka gender neutral, if and when possible. So here's some New Jersey cases regarding artificial insemination. We talked about the statute. Now here's some case law with regard to artificial insemination. One case in 2005, a mother carrying a child conceived via donor sperm asked a New Jersey Superior Court to extend the paternity presumption to her committed female partner. Over the objection of the state attorney general, the court allowed her partner to be designated as a parent on the birth certificate. New Jersey will now issue birth certificates for registered domestic partners, civil union couples, or married couples where one partner carries a child conceived via an anonymous sperm donation. Now, here's some New Jersey case law on alternative insemination. Some couples prefer to go through the insemination process at home rather than in a doctor's office. This is sometimes referred to as alternative insemination rather than the more clinical sounding artificial insemination. At-home donor insemination is legally risky because, as we mentioned earlier, the law that allows a donor to relinquish rights applies only when this process is carried out under physician supervision. So failing to have that supervision during the process could result in the donor being able to change his mind about relinquishing parental rights down the road. So what about case law regarding egg or embryo donation? Well, in 2012, the New Jersey Supreme Court refused to further extend the marital presumptions pertaining to sperm donation to egg or embryo donation when a child is being carried by a surrogate. So the case is TJS, and in that case, a woman claimed that she was entitled to a presumption of motherhood for a child conceived with her husband's sperm and an anonymous donor's egg and carried by a surrogate who had signed a written agreement to relinquish her parental rights. The couple requested a declaration of parentage and a pre-birth order to put both their names, not the surrogates, on the birth certificate. So the TJS court concluded that the intended mother must pursue a second parent adoption, emphasizing that unlike sperm donation, carrying a baby not only creates an emotional bond, but also real biological ties, because the gestational mother's endocrine system affects fetal development. And New Jersey's adoption statute prevents any birth mother, whether genetically related to the child or not, from executing a valid surrender of a child less than 72 hours following the child's birth. So how about surrogacy with two genetic parents? Well, in 2000 here in New Jersey, a Superior Court judge ruled in the case of AHW that two genetic parents could be named on a child's birth certificate when the surrogate was carrying a child conceived via the intended father's sperm and the intended mother's egg. So the order in that case included a 72-hour hold to allow birth mom time to think about relinquishing her rights. Now, the court didn't address what might occur if the birth mother changed her mind and refused to relinquish such rights. It merely just gave her the 72-hour hold with which to consider relinquishing. So is gestational surrogacy still an option in New Jersey? And the answer is yes, but only with full knowledge of all of the laws and the risks for all parties involved. Now, the non-genetically related partner here must pursue second parent adoption to ensure legal parental status. If you and your partner wish to use a surrogate, be sure to get as much information as possible regarding procedures and costs. Above all, be sure that you and your intended surrogate have adequate and separate legal representation, advice, and counsel. So some proposed legislative changes. The New Jersey Parentage Statute is always under investigation, and it's always looking for amendments or changes as technology and the laws evolve. So in June, just in 2015, there was a bill that validated gestational surrogacy contracts that complied with certain detailed requirement, was favorably reported on by the Assembly Human Services Committee, and it passed both houses of the New Jersey legislature. Now, the bill defined permissible expense payments and included medical and psychological pre-screening evaluations for potential surrogates. However, Governor Christie vetoed this bill. We're going to go on now to talk about LGBT parents and how that relates to the psychological parent doctrine here in New Jersey. So, what is the psychological parent doctrine? If you have been co parenting a child that is not your own natural or adopted child, a New Jersey court will consider what your parenting role has been with the child and whether both you and the legal parent intended for you to be a co parent to the child. The required elements to be considered a psychological parent: the legal parent consented to and fostered a third party's parent-like relationship with the child. The third party and the child lived in the same household. The third party assumed significant responsibility for the child's care, education, and development, and support, not just financial, could also be emotional, without any expectation of compensation. And the third party's parent-like role continued for long enough to establish a bonded, dependent parent-child type of relationship. You're not going to have a bonded, dependent relationship with a child if you've been involved with the child for 2 weeks. So what's the future? Can a child have more than 2 parents? Well, just in February of 2016, a New Jersey trial court examined a, quote, tri-parenting agreement among 3 friends. The 3 friends were a genetic birth mother and 2 male partners, one of whom was the genetic father. They signed an agreement, and their agreement started out well, but it went awry when the mom wanted to move out of state and take the child with her. The court found that the second father could not be a legal parent because he had not adopted the child, but the court did find that he was a psychological parent with custody rights equal to those of the 2 legal parents. Because of that, the court took an extraordinary step and awarded joint custody to all 3 parents: the biological mom and the gay couple. So now we're going to talk about New Jersey custody and support basics. These are basics with respect to custody and child support, and parenting time here in New Jersey really is a gender neutral law and does not favor LGBT parents or straight parents. So New Jersey family law, child custody, and parenting time. This, again, is governed by state law, and the statute you could see there, if you want to look it up, is NJSA 9:2-4. The overriding concern, and every court will look to this, is what is in the best interest of the children. That is the standard. New Jersey favors frequent and continuing contact with both parents. Parents are encouraged to make their own agreements, and they will be afforded opportunities throughout the court process to attempt to mediate and negotiate their own agreements. Parents can agree on any combination of physical, where the child lives, and legal custody that addresses the child's best interests. Again, it's what is in the best interest of the child, but also for the family. Child support. Child support is governed by NJSA 2A:34, and it's calculated according to a formula. The formula is called the New Jersey Child Support Guidelines. The guidelines and forms for calculation are contained in the court rules and in the appendix. Every court uses this computer formula, and it is a statewide uniform program that is used by all family law attorneys and all family law courts. So how about who pays and who receives? So the primary factors with regard to child support are the parent's combined income. It can be imputed, meaning if one parent is out of work, the court can impute to them the income that they made at their last job and then base child support off that. The number of children, each parent's percentage share of combined income, and the amount of time a child spends with each parent. So overnights are factored into the guidelines. Who pays the support? Well, each parent, according to the law here in New Jersey, is responsible for a percentage of support. Non-custodial parent pays support to the custodial parent, and with shared physical custody, so 50-50 split, 4 days on with one, 3 days on with the other, and then reverse it, or sharing week by week or even month by month, either parent could pay. It really depends on income. If it's truly a shared physical custodial arrangement and the incomes are equal, there may be no child support at all. But again, it depends on the primary factors, income, etc. So, making a claim in the courts for parenting, for custody, or for child support, claims for any of these can be part of a divorce case. They don't have to be. They can be initiated as a non-dissolution application in the family court of the Superior Court in your county. Now, if the child or the parent lives out of state, consult with an attorney to be sure that New Jersey has jurisdiction to hear the claim. If a child is out of New Jersey for more than 6 months, there is a chance that New Jersey no longer has jurisdiction, and the claim may have to be filed in the state where the child is now residing. Temporary orders are available at the outset of a case if you need immediate help from the court. Private mediation for parenting disputes. We talked a little bit about this earlier and why mediation really is a better option for families. If you and your co-parent can work together, consider strongly private mediation as a way to resolve your parenting issues. Now, one of you will still need to file court papers to have the process started and to have an enforceable agreement, but mediation can come first. Mediation protects children from conflict, and it can reduce costs, not only financial, but also emotional. A mediator does not represent you or your co-parent. Each of you may still need separate attorneys unless you choose to represent yourselves in the actual court action. So court-ordered mediation in these types of disputes can happen. The court sends most cases involving custody or parenting time issues to court-mandated parenting mediation, where each parent proposes their own parenting plan. Now, if the parents can't agree in mediation, the case is put on a priority track and the court schedules a hearing within 6 months. This is where it can get timely and it can certainly become costly. Again, if you and your co-parent cannot agree and you're going forward with a hearing, there may be custody investigations and evaluations that are either ordered by the court or requested by the parents. There are family division investigations that a judge can order. The judge can order what's called a social investigation and a best interest of the child report. This may include home inspections, may include psychological, psychiatric, parental functioning assessments, or perhaps mental health evaluations if necessary, and that includes evaluations of the children. And the judge can also interview the child in chambers. Only in chambers, a child is not put on a witness stand in an open court. Now, parents can jointly hire a mental health expert to conduct the investigation and prepare the report, or parents can each hire their own expert. Again, you can see here how this can become very expensive. Now, any child custody evaluator must be neutral and follow uniform standards regardless of who hires them. So you have your judgment for custody or for parenting time. Now it's after your judgment and you need to change the order for some reason. How do you go about modifying your judgment for custody or parenting time or child support? Well, there has to be a substantial change in circumstances that happened since you got your order in the first place. So what are some possible triggering events? Well, a decrease or an increase in parenting time. If you had only 1 day a week and now you are looking to, or you've already instituted alternating weekends and one overnight during the week, then this may change your child support. A change in the primary residential parent who has residential custody. If that changed from one parent to the other, that's certainly a substantial change in circumstances. Or perhaps a change from sole custody to joint custody, or vice versa, also a substantial change in circumstances. So courts considering a request for a big change will require proof that whatever change you're asking for is necessary to further the child's best interest. Again, that's standard running throughout all of these cases. Now, if you want more information on New Jersey child custody, we have a companion presentation to this one, Child Custody 101, an introduction to New Jersey child custody. Get a little bit more in-depth information. For more information about New Jersey family law in general, please visit our website at weinbergerlawgroup.com. There's a wealth of information there, or you can consult our various books on divorce, child custody, child support, and more. You can find them on Amazon. And of course, if you have any questions, if you need any further information, please reach out, give us a call. You see our number there, 888-855-3014. You see all our New Jersey offices listed there. We have a statewide practice, so we can represent you in any county, in any court here in New Jersey. Also, feel free to, again, visit our website. We have blogs, we have podcasts, any information that you may need about divorce, child support, custody, any area of family law. And of course, if you want to come in and talk with one of our qualified and compassionate attorneys, give us a call, shoot us an email, schedule your free confidential consultation. We look forward to seeing you. Thank you again so much for being with us. We hope you enjoyed this webinar and you found information that is helpful to you or helpful to a friend. Again, you can also visit us on social media. We are on Facebook. We're also on Twitter. And we hope to see you again next time on another webinar. Thank you again so much for being with us.